welcome to those of you who are coming on. Thank you for being here. We're going to get started in a couple minutes. While you're waiting, we will put a poll up, so feel free to access the poll that's at the bottom of your screen if you don't see it popped up. And we also want to let you know that while you're waiting, feel free to put any questions in the Q&A box, and ideally we will get to those as well. So thank you for joining us, and we'll be starting in a couple minutes. Thank you to those of you who are coming on. We're glad you're here. We're going to be starting in a couple minutes. While you're waiting, feel free to fill out the poll and put any questions you have in the Q&A at the bottom of your screen. You can see us, but we can't see you. It is a confidential webinar.
Oh, I will say, Susan, I think that their names are up there as attendees. So if
Yes,
you
but they
don't want
can't
your
see each
name,
other. Yes.
oh, okay.
They can't see. We can see who's on here. I recognize some friendly names, but they can't see each other. Yes. Correct.
Sure. And if you want to be completely anonymous, you can change your name, I think, as
Yes.
well.
Yes. Yes. Start in one more minute. Okay, we're going to get started. I know there are going to be some more people who are joining in, but we appreciate those of you who are here on time, and we don't want to make you wait too long. So just so you know, this is a New York-based information, but everything that you hear can apply to many states. I myself am a certified divorce coach, so I work with people in all 50 states. Tracy Young she'll tell you all her financials, but all the letters after her name, but she also can help in many states. And Shannon is an attorney who has been admitted to the bar in New York, New Jersey, and Pennsylvania. And so if you're not in one of those 3 states, there's still going to be a ton of information you can write down and bring back to the state that you're in. But it's really an information to help guide you, those of you that are in the middle of divorce or post-divorce and starting to think about some of these important questions for yourself and your future. So I'm going to introduce myself, and then after I introduce myself, Shannon will introduce herself, and then Tracy, and we'll get into kind of a moderator format where I'll be asking both Shannon and Tracy some questions, and we do encourage those of you who are on to put any questions in the Q&A. We'll try our best to get to those as well. So for those of you who don't know me, my name is Susan Bernstein. I am a certified divorce coach, owner of Divorce Coach Plus. I am a full-time coach. I've been doing this for 9.5 years. I have 6 divorce coaching certifications that include high conflict divorce coaching. So hidden money, domestic violence, and custody battles, which often occur during and post-divorce. Divorce and special needs coaching, which involves the intersection of divorce with special needs children. Everyone has heard half the country gets divorced, but the statistics related to divorce and a special needs child is that 80% of people who have a special needs child will divorce before that child's 21. I'm also certified in transition and recovery coaching, which also has a lot to do with this, which is why Shannon's so helpful, because I love to send clients to Shannon during and post divorce so that she can help them plan their next steps for estate planning. And I have as well the pre-mediation divorce coaching for anyone who is interested in amicable divorce and mediation. Obviously, that's the first go-to that we try. We try to keep things de-escalated and amicable if at all possible. So I help individuals pre, during, and post-divorce deal with the emotional part of divorce to prepare them for attorneys like Shannon and financial experts like Tracy. I personally am a mom of 3 children. And prior to my divorce, I was the school teacher, administrator, college professor, educational consultant. And when I went through a crazy divorce with very high conflict and my special needs daughter, I said, why me? Maybe so I can help others. And I switched from educational consulting to divorce consulting to divorce coaching. And I now teach other coaches in 2 divorce coaching programs and am a leader for 3 national divorce organizations. I'm known as the coach who people come to when no one wants to touch a problem and everyone says, I don't want to touch that divorce situation with a 10-foot pole. I say, bring it on. And I'm here to help people day, night, and weekend get through it as much or as little as they need. So that's about me. On that note, I will turn it over to Shannon to introduce herself.
Thanks so much, Susan. I'm Shannon McNulty, and I'm an estate planning attorney in New York City and the founder of the Village Law Firm. And we help our clients protect their families, their legacies, and their values. We work a lot with clients who are going through a divorce or have recently gone through a divorce. And this is something that I'm particularly very committed to and passionate about, just because, in part because we've seen so many cases where we've seen the after effects of not planning and something happens, and then it can really be quite a mess. So it is something that it is really important, and I feel like having that team in place is really important to us. And the reason that I got into estate planning was a situation in my own family where it had not been done correctly, and there was all kinds of problems, and I can see like it's so important. There's nothing more important than kind of like taking care of the people that you love, and if it's not done properly, it can cause a lot of problems for them. So when I opened my firm, I was committed to not doing like this slipshod job of just giving people some documents and letting them go out the door. I want to make sure that they and their loved ones are completely taken care of. And yeah, so hopefully will be helpful today.
Thank you, Shannon and Susan. I'm Tracy Young. I'm a financial professional with Sound Private Wealth. I have a few designations that are very specific to the conversation we're having today. So I'm a chartered financial consultant. I'm a certified divorce financial analyst and a chartered special needs consultant. Prior to becoming an advisor, I was a portfolio analyst and trader for a hedge fund. I did that for about 20 years, but the last 7 years I've been helping families going through divorce and families with special needs prepare analyses and really think through their situation so that they can get to the other side of this with confidence.
Wonderful. Thank you, Tracy and Shannon, for being here. And thank you to all the participants as well. We know that life is busy and crazy, and we appreciate your time here. So the first question is for Shannon. Why is it important to think about estate planning when you're going through a divorce? Don't you have enough legal issues to deal with?
I hear this a lot. I feel like when you're going through divorce, it's so overwhelming. I mean, there's legal issues, there's financial issues, and then you think, okay, I already am dealing with an attorney. I don't want any more attorneys in my life. And I hear you. And that is kind of part of why having a team approach, have people like Susan and Tracy to kind of like coordinate everything can be helpful. But estate planning and divorce are so related because they both deal with issues of trust. And in estate planning, you are choosing people to make literally life or death decisions for you. You're making choices of who to make decisions for you if you are going to live or die as a healthcare proxy. You're making decisions about who's going to make decisions about your money and legal decisions for you. And so when that, and you're choosing those people, you're placing a tremendous amount of trust in them. And often that one of those people is your spouse, is one of the primary people who is getting your money, who's in charge of making those decisions, in charge of being your executor. And once you're going through a divorce, often that means that trust is broken. And so now it's really important to revisit all of these decisions that you've made previously, possibly about who's going to fill these roles for you. And if you haven't chosen somebody to fill these roles, if you haven't done a will or a healthcare proxy or any of these other things, the state has chosen for you. And the state has recognized and implied a level of trust between you and your spouse that may not be there. So if you don't have those documents in place, you could end up that automatically by default, your spouse is inheriting all of your assets. Your spouse is making those medical decisions for you or managing your money. So that's really why it's so important. If that trust is not there, we need to change that and proactively put people in place who you do trust to act in your best interests.
And this is a part 2 to that question, Shannon. Just to be clear, doesn't divorce automatically revoke your spouse's rights from any estate planning documents?
So there's a lot of misconception about this, and it's technically true that divorce, a final order of divorce revokes your estate planning documents. However, it's before that final order of divorce, all of those documents are still in place. So your healthcare proxy, your will, all of those things are still effective as of the time that you put them in place. And so you really have to make those changes. Even after a final order of divorce, there are some times where your spouse can still end up with your money. One is for your retirement accounts. So if you have 401k accounts, the beneficiary on those accounts will end up with those assets. It doesn't matter that you got divorced. So that's something that sometimes people forget about. Also, sometimes in your will or in some of your other documents, you may have chosen or identified people, other relatives of your spouse. So your sister-in-law or your brother-in-law or your mother-in-law, who maybe they were part of instigating part of the problem, right? Now they are still in your documents and still have those roles even after you're divorced from the spouse. So it's even after divorce, even after there is that, even if there is that automatic revocation, it's still important to revisit those decisions.
And I can say in the 9.5 years I've been doing this, and I've literally worked with thousands of people throughout the US, and I have had people who have gotten in a car accident and been in a coma, and this is during the divorce. And their spouse was still their healthcare proxy because they didn't have a temporary one and they didn't change it. And that was very scary to that person's family members. What if he says, pull the cord, right? What if they decide not to go for? And I have also had many people, when I say many, more than a dozen, who don't even think to do a 401k beneficiary change and make sure it goes through. I do know half the divorce attorneys I know give clients a list at the end and say, do this, but half don't. And certainly probably only about 1 to 2% of the divorce attorneys will actually follow up. Hey, by the way, did you ever do that? Which is also why Tracy's role is so important, having a financial person looking and comparing and making sure as well. And I'm going to get to Tracy in 1 second, but Shannon, while we're on this topic, I just want to ask you one more question. Are there steps you can take before and or during a divorce to protect yourself and your loved ones?
Yeah. So, and this is a little bit tricky. So there are things you can do and should do, definitely. And there are some things that could cause problems if you do them. So you can definitely always change your healthcare proxy. You can definitely always create a new power of attorney. And just in case those of you who are not familiar with the term power of attorney, it's someone who makes legal and financial decisions for you if you were incapacitated. So it's a very powerful document. So you can definitely always change either of those documents. You can always change your will. After divorce is filed, then something called automatic orders go into place. And that is an order by the court preventing either party from making changes to their assets. But not only changes to their assets, but also changes to their retirement beneficiaries and changes to their life insurance beneficiaries. So once that order goes into effect, then you're kind of stuck with that. So sometimes I get the question, well, that means I need to change them before I file for divorce. And, that's a question really that a divorce attorney might tell you that it couldn't end up looking a little bit suspicious to the court that you went ahead and made these changes right before you filed. So those are things that you want to consider, and often you can't change a life insurance beneficiary or a retirement beneficiary without their consent if it's your spouse. But you definitely want to make the changes to those other documents, your will, if you have a trust, power of attorney, and your healthcare proxy.
It's so important. And for those of you who were on at the beginning, Shannon is admitted to the bar in New York, New Jersey, and Pennsylvania. If you're in another state, there are probably likely similar rules in that state. So definitely put that on your to-do list to get that checked ASAP. And I promise you'll sleep better at night knowing. So now, Tracy, you've been so patient. I know you have a lot to share with us. In regards to the financial aspect of divorce, what are some steps people can take before or during a divorce to protect themselves and their loved ones financially?
Yeah, so one important thing is to think about that going through the divorce process is not just about a settlement or it's not just about this one big number, like, oh, we're going to exchange this amount of money. It's really important to pull together all your financial statements, life insurance, any trying to think like disability, any investment statements, anything that's financial, and pull that all together and take a look at it and make sure that you understand what it is, what it does for your family. And if you don't understand it, and that is very normal, like most of us don't understand a lot of the things that we have because we put them in place 20, 30 years ago, and we can't remember why we did things. So it's really important to sit down with either the divorce attorney or a financial advisor, specifically someone who is a certified divorce financial analyst, to review those documents with you to make sure that you understand everything that your family has in place. And then think about how I'm picturing like a family that I worked with, how confident they were going into, and this can be not a high conflict or a high conflict situation. So if it's not a high conflict, I work with both spouses to make sure they both understand everything that they have so that they can come to agreements and put plans in place and go through this process together. And a lot of times that works for specific people. Or if they don't, I work with one of the spouses to make sure that they understand everything that they have, so that when they walk into a room with a divorce attorney or a mediator, they're ready, they understand, and not only understand what these things are, but how they affect their lives and why they're there, what they're there for. So that helps them answer questions such as, what kind of proposed settlement is fair and equitable to me? Because now I understand what I have, and now I understand why I have things and what they're doing for me. And now I can help figure out what's fair. And then that, having all that information and pulling together your income and expenses will also help you understand what kind of budget's realistic going forward, what will your day-to-day finances be like, and what does retirement look like based on the different settlement proposals.
I know that so many people come to me as a divorce coach, and their biggest question is, will I be okay? And when we get down to, well, what do you mean okay? Obviously, safety issues, right? But a lot of the okay is a question mark around finances. And that's why someone like you, Tracy, is so important. And certainly someone who has that certified divorce financial analyst, letters after their name. Shannon mentioned the team approach. I believe in the team approach greatly. Some people think, well, if I have an attorney, a divorce attorney, and then I have a trust and estate attorney, and I have a coach and a financial CDFA, it's going to cost so much money. You're actually saving money because you're asking the right people the right questions. Your divorce attorney is not trained in what Shannon's trained in and does all day, every day. As far as what Tracy does, I can tell you that your divorce attorney or mediator, and this is in 99% of cases, when you retain them in your retention contract, it says they advise you to talk to a financial expert because they're not one. And then when you and your soon-to-be ex or your ex-spouse sign the final judgment of divorce and the divorce decree, it also says that your attorneys encourage you to talk to a financial expert. And so twice your divorce attorney is covering their butt saying, talk to someone like Tracy, right? And I also tell people, my dad's a CFP, a certified financial planner. And people say, oh, I have a C. I love my dad. He's amazing. I use him, but not for my divorce clients because he's not trained. He's not a certified divorce financial analyst. I've never sent him one divorce client. What Tracy does specifically looks at projections, looks at tax implications. And like she mentioned, she can work collaboratively with both parties or just with one. But it's so important to have, and a lot of times you can't go back and change things. So I think everything that Tracy's saying is really true. And I feel awful when someone right the day before they're signing their divorce agreement says, well, I'll double check with a financial person now. And then to go back to their spouse and say, hey, the CDFA ran some numbers and this is not accurate. We need to readjust. People get very upset thinking they already did. So the sooner you contact someone like Tracy, who's fabulous, ideally Tracy, the better off you'll be. And I think Tracy said it, but I'll reiterate it. Most of the time during a marriage, one spouse takes care of the finances. And so for the non-financial spouse, it's very stressful. And the other thing about a CDFA like Tracy is they will hold your hand as much as you need, even if it's gathering documents. Sometimes in my sessions, I say, okay, here's what you need to prepare for someone like Tracy. So at least they go in prepared. They have questions ready. They have the right documents. So we are here as resources to help you as much or as little and really break it down. And we don't want you to put your head in the sand. We don't want you to hide under the covers. We know some days you feel like you want to, and that's okay if you do it sometimes. But the longer you put this off, the more detrimental and the higher the risk could be. So we're going back to Shannon for the next question. If you have young children, what is the best way to make sure they're provided for if something happens to you? And I'm assuming when we say young, it means not emancipated. So most states that's between 18 and 21. Okay.
Exactly. Yeah, there are specific issues that apply when you have young kids. Some of the concerns, there's two major concerns. So one is who is going to take care of the kids? So what if you have full custody? then who's going to take care of the kids if you weren't around? In the vast majority of cases, it's going to be the other parent. There's not a guardianship proceeding. It's automatically the other parent has custody. Sometimes I'll have clients who say, but the other parent is abusive or the other parent is neglectful. In those cases, it's still still automatically the default is that that parent would get custody, but somebody can challenge that. So somebody can argue that they are not a fit parent, and so somebody else should be named as the guardian of the child to take care of the child. So you want to document that in your will to make sure you're designating a different guardian, and you also want to make sure that all of the documentation of that abuse or that neglect is available, and that you've had a discussion with the chosen guardian about what would need to happen if, God forbid, something happened to you. So that's sort of who's taking care of your child on a day-to-day basis. And then the other concern is who will manage my money that I'm leaving for my child, and who's going to make sure that it's used for the child correctly. And this is a really big concern, and it should be, in part because when you pass away, if you have young kids and after a divorce, often the money is going to go to the kids, even if you don't have a will. However, if the child is under 18, then the court has to basically oversee the money. And this is pretty much in every state. Children who are under the age of 18 aren't legally capable of managing money. So the court appoints someone who's also called a guardian or conservator of the assets to manage them on behalf of the child until the child turns 18 or 21. Often this is the person who the court appoints is the guardian of the child or the parent of the child. So that's exactly the person who you probably don't want to be managing that money. So if you don't have any plan, that's basically what's going to happen, is that your former spouse, even though you're totally divorced, even though he doesn't end up like inheriting your assets, he's going to end up controlling them through your child. So it's really important to make sure that you do a will. I also would recommend that you do a revocable living trust. That helps to protect your plan and prevents people from, particularly ex-spouses, from asserting any objections to your will. It makes it harder to contest, and it has more privacy. So I would recommend doing a revocable living trust and leaving the assets in a trust for your child. And you would appoint a trustee to manage the assets. So that should be somebody who you trust. Maybe it is your former spouse. Some cases that is the case, but often it's not. So you want to make sure that it's somebody who you trust, independent of that.
I've heard that some people write a letter of intent, and that's more popular nowadays. So it's specifically what would happen in details. Do you see people doing that, or do they put that letter attached in their will? Obviously, it does not replace a will. So we know that, right? We want to make sure people know a letter of intent does not replace the will, but where does that fall when they have a will?
So, a will itself is like pretty cut and dry often. There may be often, if you have like tangible personal items like artwork or books or jewelry, things like that, that might not be specified in a will. So through like a letter of intent, then your executor can distribute those things basically based on your wishes. But where a letter of intent is really comes more into play is where that person is managing money for somebody else. So if it's like a trustee, so if you leave money for your child to a trust, then having a letter of intent as to what your priorities are and how you would approach, how you would want that person, that trustee, to approach spending for your child, whether you want to make sure that their education is covered, their have money for a first house or something like that, then you can put that in a letter of intent. So it's not legally binding, but it helps whoever is administering the money to know how to do that in a way that would be in accordance with your wishes. So I think
Tracy,
froze.
if she has anything to add. Oh, am I frozen?
Oh,
Can you
you
hear
just
me?
you
Your
just
picture.
came back. You just unfroze. You just thawed. Oh, there she goes.
Okay, can you hear
Actually,
me?
I can't add
I
anyway.
heard it going a little fuzzy. Okay, so hopefully you can hear me now. So I'm going to direct this next to Tracy to see if she has anything to add to what Shannon just said. And on top of that, while we're talking about minor children, how child support potentially could negatively affect any special needs children's benefits or anything like that while we're talking about children and plans and letters of intent.
Oh, and just one more thing before,
Oh, yeah.
sorry, before I return to Tracy, is that in terms of the letter of intent, that's also can be used for your guardians of the child. So of how you would want your child raised, that's a really good way to do that because you're not able to do that through a legal document.
Wonderful. Thank you for clarifying, because I was actually even confused about where that letter of content goes and who it's addressed. So one for the guardian, one for the trustee, so they can know about the care of the child and about the finances. So it's very clear. Thank you, Shannon. Okay, Tracy.
I actually will have a comment about the letter of intent also. When I'm working with my families that have children with special needs, or even adults with not minors. My families, I encourage them to write a letter of intent to include all the very specific things that their child or adult who's disabled with information about how to care for them, things that they like. I have a nephew who's about 6 years old, and he's not he doesn't speak. So a letter of intent would be really important to tell us what shows he likes, what music he likes. So a letter of intent when you have a child that's disabled is really important for the families. And yeah. And then also when thinking about divorce, and if you have a child with special needs, and just like Susan mentioned, it's really important to speak to a special needs attorney. I know I'm adding more people to the team, but special needs attorney or chartered special needs consultant who can help you review the documents to make sure that there isn't anything in the documents that will prohibit your child or young adult or adult from receiving the benefits, government benefits that they either are planning to receive, because that's I think where a lot of the problems come in, is that they're not receiving benefits yet. So it's not thought about while they're going through the divorce, and then the child support could potentially show up as income to the child, which will then prohibit them from receiving government benefits. So it's really important and this is very difficult to do, but it's really important to look into the future and talk to other professionals who can help you look into the future. And so that you can think through these if-thens that could happen, so that so you don't have a divorce agreement that then causes a problem later on.
Absolutely. And, we kind of covered this, but I'm going to bring it back to Shannon and I'm going to add something. So about making sure that an inheritance that you intend to leave to the children doesn't end up with the ex-spouse. And then part two of that, because I know you talked about it a little, is to me, hearing all this is why you need to work with someone like Shannon or Tracy, because so many people say, oh, I downloaded a will online. I downloaded this online. Well, when you download it online, you don't have anyone to converse with. You don't have their knowledge and their experience where they can say, wait, your specific child has special needs. We need to talk about this. Your specific child has this. We need to know about, hey, the grandparents had a generation skipping trust, or the grandparents had this. Like, so I think this is just this conversation we're having shows the importance of not only why those online documents are not good, but why they could really nip you in the butt, and what you think you might be saving money on could actually lose you and your children a lot of money. So Shannon, it's a long question, but you know what I'm getting at.
No, absolutely. And actually my father used a very cheap attorney. And later on, we found out, why he was so cheap. And so there's a saying of there's nothing more expensive than a cheap attorney. That it's very true, because it caused a lot of problems, and you just don't want to leave these kinds of things to chance, especially, just taking care of your loved ones. And it was a situation in our family, somebody who had disability, and the documents weren't really drafted to protect against that. So even if you don't have a child who has a disability, you don't know in the future if you will have, even if you have all of the children, you don't know if they will have a disability in the future, right? So some of these things that you're planning for a future you don't know about. And so that's where I think it can help, you're just not thinking about it. You were not trained to think about it. Our brains don't like to think about it. But these are the kinds of conversations that we have with our clients, and it's important to think about. I think one of my clients said, so basically your job is to have like really difficult conversations with people. I'm like, yeah, that's pretty much my job.
Absolutely. And it's such an important one, and people don't realize until it's too late sometimes. And my goal is to have people be a step ahead, and to have people say, wow, that happened to that other person. I want to make sure it doesn't happen to me. I know sometimes when someone's going through divorce, they have a mentality almost like a teenage mentality. Teenagers think, oh, I can drink and drive. I can have unprotected sex. It's like nothing's going to happen to me. And when people go through divorce, I've also often seen them say, this is the most awful thing. Nothing else bad could happen. So I don't need to do that because all the bad stuff has already happened. And then it does get worse, right? In these situations where they think nothing else bad is going to happen. So I see that in divorce where they think I've already gotten all the bad karma, or anything I ever did wrong has come back. I'm done. And it's not. So you do need to do that. So on to Tracy. Anything you want to add, comments about inheritance, considered separate property, premarital property, things like that?
Thank you, Susan. Yeah, just being that we were talking about inheritance, I thought I would mention when you're going through a divorce, your typically inheritance is considered separate property as long as you have kept it separate throughout the marriage. If you received an inheritance while you're married and you put it in your joint account and then bought things together in that account for your house or wherever, then that would then become marital property. So just thinking about that, it's important to keep that separate and not to commingle it with your marital funds.
Absolutely. And that word commingle is important. And I know, Tracy, as a financial specialist, you often talk to people about the importance of documentation. And I've certainly worked with people who have been married 10, 20, 30, 40, 50 plus years. And the ones where question marks come up on finances, who had the documents as far as who paid for the house, was it premarital, what inheritance was commingled, what lawsuit settlements were commingled, that's the ones that the judges look at, right? So certain documents, even though they might be old, are so, so important. Shannon, I see two questions here. I'm going to read them in the Q&A because they probably apply to more than one person. One question said, should someone advise the grandparents for estate planning so their assets go to the child and not the divorced spouse? How do they need to, what do they do in that case?
Yeah, that's a great question and is something that we deal with a lot. Even if, so a lot of times, well, especially if you've gone through a divorce, then you want to make sure that your child doesn't, whatever you leave your child doesn't end up in a divorce situation or getting used by a former spouse. So you really want to leave assets when you're leaving an inheritance to someone, and you want to make sure it's protected in case they get divorced in the future, or especially if they're currently going through a divorce, that you want to leave it in the form of a trust, basically. So leaving it to a trust for that person, even if it's an adult child. We do this all the time. And so a lot of people think, oh, it's only for minor children. It's only if you have like tons of money. No, it's actually super helpful for almost anybody. And it provides a kind of protection that you really just can't get after if you don't leave it that way. If the money goes to them, they can't then put it into a trust for themselves. It just doesn't work that way. It has to be a trust that the grandparent or the parent, whoever is leaving the money, sets up and leaves to the trust. In that way, it's protected against a divorce. You have to be very careful, though, about how that trust is managed, how the money is used. But that is definitely the safe way to go. But definitely, you want to talk more about it to an estate planning attorney about exactly how that money would be managed in order to make sure it has the most protection possible.
And for someone who is talking to their parents, they might be my age going through a divorce and they're telling their parents, hey, you need to, review your documents so that my soon to be ex doesn't get money or my ex doesn't get money that wasn't intended once we're divorced. How often should someone review? Every 5 years, every 10 years, just with a life change?
I would say at least every 3 years.
Oh, wow. Oh, good to know. Mm-hmm.
Because things do change. And if you're not kind of having it top of mind, that changes to who takes care of your kids as a guardian, right? Somebody moves away and then, or they get sick, they can't be your power of attorney anymore. So these are things, even if kind of like your life doesn't change, maybe somebody else's life changed and now you're not in a position to take on a role that you had previously thought.
That's absolutely great thinking and great advice. And I'll make sure to tell my clients that as well. I was telling them 5 years, but we'll go to 3. So the other question in the Q&A, it said, oh, go ahead.
Yeah, so it's also, I mean, actually with our clients, we have a service and most of our clients enroll in it where we meet with the clients once a year. And just to make sure, like, do they have a new 401k? Is the beneficiary updated? Like making sure everything is going to their trust. Did they purchase a new property? So any of these things, you just want to make sure everything is set up properly, even if you don't need to change the documents, that some of these things you want to make sure that can easily kind of like go outside of your estate plan and mess things up. So I think it's helpful to kind of like review these things even every year.
Absolutely. And this next question says, can you commit the other parent to have a relationship with the deceased parent's siblings?
I feel like this is like a law school question.
Yeah. And it's also, I think, depends on what's written in the divorce agreement as well as in the estate planning, right? Because a divorce agreement, both people are signing. So maybe if in the divorce agreement it was written that if either parent dies, they'll make sure the child will still be in touch with the other side of the family, versus an estate planning is when you're divorced, it's your estate plan. So I don't know if you, as their estate planning attorney, could have their spouse commit. You could write it as their preference or their letter of interest, but I'm not sure if it would be more for you. And then even if it wasn't a divorce decree, I don't know how enforceable that is, because what is the consequence if they don't, right? And so we always talk about that. But any insight, because they asked this question, I'm just reading it aloud.
I'm just starting to realize what the question kind of like process
Yes.
of like, it's the
Yes.
parent like a minor child
Yeah.
that you want, basically that you want the children to have a relationship with like their aunts and uncles, I think is
Yes. Mm-hmm.
the idea. And the short answer is you can't really do that. All you can really do is hope for the best, and you can write the, so I will say the way that you can do it is you tie the money to it. So you can control your money. You can't control the guardian, but you can control the money, and you can say that the money, you know, more basically we'll give you money, but we're going to be a lot more strict if we don't have a relationship with this child, and that could have a lot of influence.
Okay, that's a good way to think about it. And Tracy, I'm going to bring it back to you as far as some comments related to your specialty. We talked about how Shannon encourages her clients to, you know, once a year at least check in, every 3 years, really do a deep dive into what changes either they have or the people named in it have. Like, it's in something for mine, I'm thinking one of the people moved to Florida. I might want to reconsider now, because what would happen to my child? Would they go to Florida there? You know, so thinking about these changes, I think, you know, this is thought-provoking for all of us. But so Tracy, as far as how often to meet with you during a divorce, post-divorce, thinking about protecting assets, we talked about some trusts, but anything that you can give people as far as tidbits of information to think about, and certainly to have follow-up consultations with you on.
Yeah, so Shannon, I love that you meet with your clients once a year, because it's exactly what you said. If it's not top of mind, when that 5 years comes up, they'll be like, no, nothing's changed, you know, and then the year goes by, and or 3 years or whatever. So when I'm working with clients as a certified divorce financial analyst, I work with them prior to the divorce, throughout the process. Once the divorce is final, that relationship comes to an end officially. And then I can then put on my financial advisor hat. And if they would like to move forward and would like some help going forward in that, with that relationship, then I can always do that. With my advisory, with my financial planning, that hat on, I meet with my clients once a year. We actually have to, we have no choice. It's the rule. And during that time frame, we do go over, well, anything that's changed. And that could be, I mean, we call it holistic life planning, because it's looking for any kind of changes. What are your kids up to? How's your job going? What are your values, and what are your top values, and have they changed? Because very often your values and what you're want to put your money and energy into can change over time based on what's going on in your life. So we dig pretty deep trying to figure that out, and then try to make sure that your financial plan is following along with any of those changes. And when we meet once a year, we do check beneficiaries and that sort of thing, but I'm glad someone else is checking too, because a lot of times I stay on top of people and keep emailing and emailing. Did you change? Did you change? And they don't. So I need a team effort here to stay on top of that, because of all the terrible stories that we've heard of if you don't do this, you know. And then it's the best thing, because I don't like annoying clients, but I have to say that is one time where they always say, "Thank you so much for staying on top of me. I really needed somebody to keep reminding me to make that change." So yeah, so there's the two hats. One is that as a certified divorce financial analyst, working with clients as they're going through and until that ends. And then switching hats to financial advisory. And in the middle of all that, I work with families that have children with special needs. So that can be whether that's a family going through divorce or not.
Absolutely. Thank you, Tracy. So much knowledge and expertise on here. There is another question that popped up. So this person is not yet divorced, but they would like to have a trust prepared. They're worried about like their kids. So knowing they're not yet divorced, could they start to work on it? And or what happens if someone has a trust when they're married and then they get divorced? Does that trust need to be readjusted?
Yeah, it definitely needs to be readjusted. And the things, and I think in this particular case, there's maybe minor kids that you want to make sure that it's, or for my clients in this kind of situation, I recommend doing a revocable living trust and making sure that you name a trustee to manage the money for the children. Make sure that this is a little bit in the weeds, but I'm going to give it anyway, that the trustee has full discretion, meaning that they can withhold money that will, and depending on what the situation is with the spouse, if there's, a real lack of trust and you're concerned, that you want to make sure that you kind of give the trustee very tight reins, that they would be able to kind of like do whatever needs to be done with that money. Including in some cases, I say I include in the trust fight for custody if it's a case like that. But I think just having a will, doing a revocable trust, leaving the money to a trust for your kids, that those are the main issues. And then of course you want to definitely redo your healthcare proxy and your power of attorney are really important as well.
Absolutely. And I will reiterate it again, just that, Shannon she is admitted to the bar in New York and New Jersey and Pennsylvania. So if you ask any of these questions, just double check with someone in your state just to make sure what she's saying is true for your particular state, because as we all know, divorce laws vary by state, and so do trust and estate laws vary. And so as you can see, Tracy just put up our contact information. We see we're coming to the top of the hour. We encourage you to take a screenshot of our information instead of trying to jot it down. Feel free to jot it down. It'll be up here, but sometimes if you take a screenshot, that's great. I know I always offer complimentary calls. You can email me to set up a time. You can text me to set up a time. And I really try to have a flexible schedule where I can, meet your needs day, night, or weekend. And then for my services, just so you know, I'm not a therapist. I can't hail your past the therapist you see every Tuesday at 10. For me, people buy a package of sessions, either 2, 5, or 12 sessions. That's each session is an hour. But everyone gets that complimentary call. So you have nothing to lose because it's confidential and non-judgmental. And I'm going to let Tracy and then Shannon let you know how they would work if you wanted to meet or retain them.
Thank you, Susan. I am similar, I guess, for CDFA work. So for divorce planning, I have a free consultation, and then we come up with the situation and what questions you want answered, and then based on what the question is, because there can be many things that we're trying to figure out, we would talk through the structure of how to, it's an hourly rate, and but it depends. It could be 2 hours, it could be many more. It really depends on what we're trying to calculate or figure out or plan for.
Sure. And if you've registered and watched this webinar, you definitely will do a complimentary consultation. Just make sure that you mention it when you call or when you email. And we work on a flat fee basis. And like Susan said, I'm licensed in New York, Pennsylvania, and New Jersey. And but a lot of the things that we've discussed here can apply to other states. So, but if you are in a different state, I would encourage you to speak with an estate planning attorney in your jurisdiction.
And from my coach's hat perspective, I'll put on the emotional aspect because that's what I do is I help people with all the emotions. And I'll say, certainly this is a stressful time. Change is scary. We like to turn the scary into an opportunity. We like to turn the change into something that you feel good about. We talked at the beginning, will it be okay? Yes, it will be okay, because you have your emotions in check if you work with a coach. You have the peace of mind knowing that your wishes will carry through if you work with Shannon as an estate and trust attorney. And then you have your answers as far as finances, right? Do I need to cut down on my money? Do I need to get a part-time job? Do I need to get a bigger job? Like, what do I need to do to be okay? So we are the resources that help you sleep better at night, knowing, wow, it will be okay. And it's scary, but I'm going to get through it and it is going to be better in the next chapter. So we thank you for your time and we look forward to working with you. Have a great night. Thank you.
Thank you, everyone.
Thank you, everybody.